All right, good afternoon. This is House Judiciary Committee on March the 21st. We have a number of bills, including one by a Senator Ferguson. Mr. President, if you'd like to come forward, that'd be fine.
Just touch it. Okay, there we thank I know. Thank you, Mr. Chair, Madam Vice Chair, members of the committee. It is a pleasure to be here with you all. Happy crossover. This is an important and excellent bill. Unfortunately, my House cross file decided to leave it to the senator to do the heavy lifting. And so in all seriousness, you all have heard this bill before, and Senate Bill 774 is a bill that establishes the Maryland Entertainment District Security Grant Program. It hails from, and sort of shifting gears, a pretty tragic incident that happened in our district, in the 46th district, this past year, where a sheriff's deputy from Howard County was there with a number of friends, enjoying himself, and an individual who had a concealed carry permit, not on him at the time, but went and found it. Something must have happened. There was an altercation, and the sheriff's deputy, Ryan Dempsey, was shot and killed in Federal Hill. And the challenge was that this, just around the corner, the Orioles had just clinched, and there was a large crowd. It was a large gathering in Federal Hill, as often happens in a number of places across the state, but in certain concentrated areas. And so this bill arises from the recognition that in several parts of our state, from Frederick to Ocean City to downtown in Baltimore, number of places in Baltimore, and downtown in Columbia, there are certain spaces that have an upsurge in the number of attendees. And so while it is normal for law enforcement officers to be able to patrol those areas, there are certain times where enhanced security efforts are necessary in order to make sure that people can enjoy themselves safely. So this creates a permissible fund for those local jurisdictions to tap into. It is not a mandated appropriation. It is permissive, and would allow for a local community organization in an area, called a main streets or some related function, to be able to access the potential of additional dollars to have security for those places and spaces that have high concentrations of alcohol, licensed premises. And what was amended in the Judicial Proceedings Committee was to also include hookah lounges in that. And so with that, open to any questions, and appreciate the committee's favorable consideration.
Anyone with questions on the bill? Delegate, the Vice Chair.
This will probably be my only opportunity to ask you questions, Mr. President. The last
I
thing,
hope not.
the last thing you said, you said two words. I just couldn't hear you. You said it would not only add, allow for situations where there's alcohol or something. And you said I'm sorry. Lounges.
The hookah lounges.
Oh,
hookah lounge.
Okay,
it was licensed, established, like it was initially as drafted around licensed beverage establishments, and the Judicial Proceedings Committee added hookah bars as part of the concentrated. And there would be regulations that would have to be drafted up by the department first.
Anyone else? Yeah, you're letting them off the hook too easy. All right, that sounds good. I don't think there's anybody else in opposition. That concludes the testimony for Senate Bill 774.
Have a wonderful next 19 days, and congratulations on your wonderful Founders Speakers Award.
Thank you very much.
Yes.
Appreciate that.
Excellent.
All right. Okay. Is Chair Smith? You get all the big hitters, I guess, today. No Chair Smith, or anybody here for Chair Smith? Oh, it's B. So we're doing, okay. Oh, that's fine. We can do, go ahead. We'll do this, and then we're going to go over to the administration bill next. Or do you care?
I wouldn't presume to go ahead if any of the Senator West.
Senator Bailey, sit down. Go sit. You're fine. Senate Bill 7, please.
Thank you very much, Mr. Chair. As Vice Chair, members of the committee, Senator Jack Bailey, representing St. Mary's and Calvert County District 29. Senate Bill 7 is the positive community feedback bill for members of law enforcement. This bill is the cross file of House Bill 973, which passed this committee, and the full House of Delegates. I've had the opportunity to review the amendment that this committee put on the bill, and I fully support it. Therefore, I respectfully request a favorable report with that amendment on Senate Bill 7. I thank you all for your consideration, and I would stand for any questions.
Well, you're sitting, Senator, so. He's willing to stand. That's very nice. That's very kind. Are there questions for the senator? Here all week, everybody. All right. Thank you very much, Senator Bailey. That concludes the testimony for Senate Bill 7. There's Senator West. Let's hear from him on Senate Bill 23.
Thank you, Mr. Chair, Madam Vice Chair, members of the committee. It's great to see so many old friends as well as some new ones here this afternoon. I'm here to present Senate Bill 23, which is about orphans courts. But let me start by talking for a minute about circuit courts. I'm about to turn 74. I will turn 74 the day before we adjourn. And for as long as I can remember, we have elected circuit court judges on a nonpartisan basis. So everybody who's filed will be listed alphabetically on the Republican primary ballot and on the Democratic primary ballot without regard to party affiliation. The voters will be asked to vote for however many positions are open. Whoever, if the same people win both party primaries, they're the only names that go on the general election ballot. If in the Republican primary A, B, and C win, and the Democratic Party A, B, and D win, all those four names, A, B, C, and D, will go on the general election ballot, and the voters will be asked to vote in this case for 3. That's the way it's always worked, and it's worked well. We elect circuit court judges based on their qualifications, their experience, their probity, their professionalism, and the demeanor. We do not elect circuit court judges based on their party affiliation, and thank goodness for that. We do not want our circuit courts to be occupied by judges known for their party affiliation, and we don't do that here in Maryland. This bill puts orphans court judges in exactly the same position as circuit court judges. We will elect them without regard to party in exactly the same way, and put an emphasis on their qualifications and their professionalism rather than their party affiliation. So many people don't know what orphans courts do. They don't really deal with orphans. Orphans courts handle the administration of estates and the interpretation of wills. There is no partisan connotation to how estates are administered or wills are interpreted. We had testimony in the Senate from orphans court judges who said that never have they ever had to render a decision that involved partisan considerations. So in the Judicial Proceedings Committee, the vote on this bill was unanimous. On the Senate floor, 10 of the 13 Republicans voted in favor, and every single one of the Democrats voted in favor of this bill. So it was a bipartisan vote, overwhelming bipartisan vote, without regard to party affiliation. So I urge this bill on you. I think you've probably heard it before. I hope that you'll consider passing it this year, and I'm happy to answer any questions you might have about it.
All right.
Okay.
Seeing no questions. Thank you very much, Senator West.
Thank you so much.
Testimony on Senate Bill 23. We'll go now. I see Senator Sidnor here. I don't think I see any other senators. So we'll go with Senator Sidnor then, because you're here. Senate Bill 57. Senator Sidnor.
Thank you and good afternoon, Mr. Chair and my former committee. I miss many of you as well. You got that? No, I'm joking. Look, he meant that. Look, I had an opportunity to listen in on the hearing that you all had on HB 392, and the reality is there is not much more that I can add to the testimony that you heard from the sponsor, his panel, or anyone else. But what I would like you all to do, because I know there are some people who don't want to open up the two-party consent with the wiretap, I will say that you all passed House Bill 290, which opens it up a little bit. I went through the Department of Justice's website to look at some of the cases that we're kind of talking about when we're talking about Fair Housing Act and violations and why this type of legislation is needed. In one case, you had an alleged owner and manager of 3 apartment complexes in Pearl, Mississippi, who discriminated on the basis of race by steering black testers toward one complex and falsely representing that the other 2 complexes did not have vacancies. Some of you all talked about the ability to get a warrant or something like that, which we all know you can't do it because it's nonprofit organizations that do this stuff. But how are you going to have facts to show that I was steered towards one place and not another, and white people weren't? Can't do it. They had another case in Oklahoma where they rejected a housing applicant from complaint for a minor child on the pretext of the lack of available housing. And when they further misrepresented the availability of housing to a black tester after showing numerous available units to a white companion tester. You had cases where there was discrimination on the basis of sex in violation of the Fair Housing Act because prospective tenants were sexually harassed. I mean, you had people, and this is something that had transpired in Baltimore City, where you had people who work for agencies asking for certain sexual favors and making sexual comments and advances towards female tenants. Look, I used to do some volunteer work for an organization called Baltimore Neighbors Incorporated. I did this stuff. And what we had to do, and as what was testified to you all, you would go in, see how you were treated, then run back to your car and write down your notes. So the question is, do you want to depend on the notes that I'm writing, or do you want to depend on me putting a phone in my recording what transpired? With that, I stand for your questions. I don't know if that's a good thing. I wanted questions.
I'm not sure if someone wishes now to ask him questions.
Please ask.
All right.
I need questions because I want to know why the House bill is stuck here. So what are your questions?
So I guess then let's go to the issue of 2-party consent generally. And so we did have 290 here, and we've had that bill a couple times, bill that JPR didn't pass. But having said that, we've been bandying about this broader issue with regard to 2-party consent or 1-party consent. And are we at a point, do you believe that we're at a point where we need to just look at the bigger issue of whether we should have 1-party consent generally or not?
And I appreciate that because I've had to have this conversation with Chairman Smith, and I will tell you, he resisted, and I had to keep talking and talking and talking. He resisted going forward because he's very protective of the 2-party consent. For those of you who know my legislative history, I am as well. I mean, when we talk about many of the issues and bills that I've championed, whether it be in genetic genealogy or cell site simulators and things, it was always about privacy, always that libertarian bent. However, in this case, you're talking about something different and something that's more narrow. I am not looking to get rid of the 2-party consent. I like the fact that I'm able to walk out and know that I can have a private conversation and not worry about somebody recording me. However, in this case, we're talking about people who are engaged in commercial activity that affects people's lives. I heard in your hearing where you all talked about that right of privacy. So the question is, are we going to allow that right of privacy, which I would contest? You don't have a right of privacy when you're talking about in this commercial context versus that right to housing. We're talking about people discriminating for whatever reason within that against people within a protected class from being able to live peaceably and find somewhere to live. So no, I'm not at that point either.
Okay, I understand. Now we do have questions.
All right.
So I'll go with Delegate Phillips to begin, then Delegate Schmidt. And then I'll note that now we've had a couple more senators show up because Senator Sidnor killed a little time. Senator, I'm sorry, not Senator. Delegate Phillips. Don't tell Ben. All right.
Thank you, Mr. Chair. During the hearing, there was a few questions that were raised on the House side. And one of them had to do with kind of determining a good cause and determining whether it would make sense to give people an opportunity to verify why they might use a recording after a subsequent engagement with a housing official. How do you feel about that?
So when tests are done, and I believe I heard someone from Anne Arundel County talk about this, not only are you going to have tests when there have been complaints that are complaint-driven tests, but you have systemic tests or these audits that are done. Those audits are done when people go out in the field and they try to ensure that discrimination is not happening. When you look at one of the cases that I talked about where people were staring people, again, if I'm being stared, if when I go in, I'm speaking with a manager or whomever it is I'm attempting to purchase a property from, they could treat me as nice as they want to be. And I do not know that I've been discriminated against until you take my evidence and that of the testers that have gone in, you set it side by side, and you then all of a sudden you see, hold up, they're only showing Senator Sitnor one place, but they showed this white tester who's similarly situated 5. You're not going to know. People aren't generally going to be nasty to you. They discriminate. It will smile in your face. And so the solution that you mentioned, it would hamstring these types of investigations, and I would resist that.
But today you don't have that tool. So if you established a predicate, you would have that background if we're going to protect kind of this two-party consent and have a narrow, situation that we are now addressing.
So today, what you're going to have is me and other testers going in and writing down those notes, and then people kind of just going through the notes. So the testing is going to happen. Right. It's just a question of best evidence. So yeah, that's what I was saying with that.
Yes, thank you, Chair, and thank you, Senator, for being here. I have a couple of different questions. Do we currently have testing that's occurring now?
Yes.
And you brought up, I believe, a case in Alabama. Was that correct? How many cases in Maryland, or do you have any specific statistics? And then my third part, you did watch the testimony, and it talked a lot about third-party ulterior motives, whether we're using a nonprofit or a third-party organization. And I think that was kind of the largest part of that, was the financial, perhaps, gain from the third party. So maybe you can answer those two questions.
All right. With regards to the first question, I know in speaking with Marceline White, they had 142 intakes, 56 discrimination cases that were resolved via advocacy and mediation. 41 were forwarded internally to their tenant advocacy program and resolved. 38 were closed due to unresponsive clients. 7 cases were forwarded to the Civil Rights Commission, DRM, and legal aid. Let's see, 48 tests focused on source of income discrimination, lending, and reasonable accommodations in Baltimore City, Baltimore County, Prince George's. So that's the first part. The second part, what was it about third parties?
A lot of debate was over, and this was not just debated in the hearing, but it was also debated in a lot of the voting session was about the third party ulterior motives and, nonprofits receiving financial gain or receiving funds to basically find violations. Or I think that would be my question, is looking at that third party situation there.
So let me respond this way. The state of Maryland and our local governments receive a vast amount of money to affirmatively further fair housing. We have a responsibility and a duty to ensure that fair housing laws are effectuated properly. Maryland is one of 11 states that's hamstrung because we do not have this ability to capture this type of evidence on, I was going to say on tape, but nowadays I guess it's not really a tape recorder. That's old school. But so what happens is And in fact, I was speaking with an investigator up in Frederick, Maryland. His office, I think he works for their human resources. His office is one. Again, I don't think many, whether it's local government, even state government, if you were to look at the size of MCCR, it's not very large. We do not put resources in ensuring that civil rights are effectuated. We put the laws on the books. We want to say there should be no discrimination, but what's the enforcement mechanism? Because those offices are small, what they then tend to do is they're able to hire or contract out to third parties that do it, your nonprofits. And it's those nonprofits that conduct that work. When I used to do it, the organization was called Baltimore Neighborhoods Incorporated. Baltimore Neighborhoods Incorporated, I believe they dissolved a few years ago. But I mean, trust me, no one's getting rich making certain that landlords and multifamily units and the rest are acting in accordance with the law. This is a tool that the AG came in and said they could use. Many of your local governments came in and said they could use. I know Baltimore County came in, said they could use it, Anne Arundel County, and a number of others. It's another tool in the toolbox to make certain that people are able to address and attain their right to housing.
Source of income you touched on seems to be a big question mark, right? And do you know when that became a protected class?
When we passed the Home Act a few years ago.
Okay. And I think a lot of it's education, right? And I think a lot of it is.
And I'm sorry, I shouldn't even say it was a protected class. It was just something you couldn't discriminate.
Sure.
So not a protected class.
Yeah. And I think a lot of the people that you're referencing probably don't understand what source of income either means,
right.
And a lot of it talks about our voucher programs. And I know that those are very important to a large population, and we probably need to educate a lot of these landlords
right.
on that. So,
and something that, again, when I was with BNI, that was something that they did. They had programs to ensure that they were educating landlords on these things. And they were not always going out actively suing. If they saw an issue, they would then go in and say, look, landlord, there's an issue here. This is what we found out. Here's some materials so you all won't be doing this anymore. So education does happen.
Thank you, Mr. Chair. Really quick question. Hi, Senator. How are you?
I'm doing well. Thank you very much.
Good.
All right. That's a good one.
That was that question. Do you have a follow-up? I do have a follow-up. My follow-up is, how do you, just playing devil's advocate here, how do you think, and I know there's been a lot of discussion, so my apologies, it will impact those residents that may not be doing the right thing in their communities? I know that we want to offer protections as well, but what about those residents that may not be on the up and up? How would this, I guess, wiring impact that? Would they get
the residents? I want to make sure to understand your question.
the tenants?
How would it help the tenants?
If the tenants was doing something inappropriate?
Well, again, this ability to record would be done by fair housing testers. That's it. No one else. Yes.
If they do see something inappropriate, they're not going to say, hey.
Fair housing testers
Okay.
tend to go out once they've been given an assignment and they've gone through training.
Mhm.
They're not just me willy-nilly going out by myself deciding I'm going to record you. That's not what this bill does. It's about people who've gone through a specific type of training and doing it on behalf of these organizations that we've allowed to do it.
Okay, I'm just looking at unintended consequences. I have so many bills, so I didn't delve into the weeds.
There's no
of this.
unintended, again, this is
Okay.
not, as I believe the good delegate sponsor over here said, this is very narrow. This isn't about blowing up the two-party consent, and this would not be, Maryland would not be the first in around the country doing this. It's nothing new. This is a best practice that HUD advises that one should do. We just can't do it because we have this state law. It's constitutional as well.
Thank you, Mr. Chairman. Thank you, Senator, for your coming in to testify.
Body camera
work
man.
on the body cameras, yes, sir. So how would the assignments be chosen?
You know, and again, I'm reflecting on my time when I was at Baltimore Neighbors Incorporated. It would depend. So if there was a question that it was racial discrimination, you would then look at your roster of volunteers and you was like, all right, who do I have that matches that class? Who is it that we believe that they're not discriminated against? And you would pair them up and send them out. If it's a disability case, you would find someone with a disability. If it's a gender or a sex case, so it all depends on what the assignment is and what you're looking for.
Would it be driven by a complaint?
It can be driven, most of the time it's driven by a complaint, but it's not always driven by a complaint. Sometimes it's a thing of we need to test to make certain that nothing's going on. They go in, they don't find anything, they stop, they move on.
If I may, so follow up on that, is this audio only or audio and visual?
Well, as you know, as body
Oh, I
camera
know.
man, it's all right to capture video. There's nothing illegal about capturing video. But if you have these sexual comments or you have these racial comments, it's the audio portion that we're trying to capture. Thank you very much.
Thank you very much. That's going to conclude the testimony in Senate Bill 57. Thank you. We're going to
Thank you all
go.
for those questions.
Thank you. You're welcome. You're welcome. See you soon. Senate Bill 827. Mr. Chairman, come on up. Then I see Chairman Smith, then Senator Carter, then Senator McCray. I think I see those. Okay, go ahead with Senate Bill 827.
Thank you very much, Mr. Chairman, Madam Vice Chair, members of the committee. Senator Smith here to present Senate Bill 827. Mr. Chairman, this is the direct cross file of Delegate Phillips. Do you want me to go into the bill, the mechanics of the bill, or do you want me to talk about how we've
How
changed
it left the Senate. Yeah.
Okay, all right. So we made two minor changes. One is on page 1, line 17. We changed the purpose of jury examination instead of it's a very substantive change. Shall be to is just is to. And then we've added a work group. This work group was done in consultation with the judiciary, who weighed in with a letter of information. So the work group will be staffed by the Office of Attorney General, also consulted. It'll have two members of the General Assembly, one from the Senate, one from the House, and one from the judiciary. And their purpose shall be to study the voir dire process. And with that, Mr. Chairman, I will stand by to take questions.
Questions, Delegate Williams?
Thank you, Chair Smith, for being here today.
Sure.
And I appreciate kind of the changes made to the bill. I guess my question is if this is even necessary. And the reason I asked that question is because it's my understanding that the Rules Committee for the Judiciary already studied and examined this previously. And I think there was a recommendation previously from the Rules Committee to modify voir dire in the fashion of the original posture of the bill. And so I guess how is this work group going to differ from what was already done by the Rules Committee for the Judiciary in this regard?
Well, the work group has an effective date, June. Thank you very much, Delegate, for the question. The work group has an effective date of June 30th, so it'll go into effect before the October 1st effective date of the statute. As you know, the Rules Committee did take this issue up about 10 years ago. They and the recommendation of that report, I think it was a years-long study, was to change the voir dire process to look something like what we have here that we're offering into statute now. Unfortunately, nothing has happened in that 10-year gap of time, and hence the reason why we're here now. This bill is supported by every, a bar association affiliated with, from the Born Bar Association to the Hispanic Bar Association. So widely supported through a broad swath of legal professionals. And so that's why this work group is there. It'll help, I think, evaluate the process as it is now and how this might be implemented most successfully when it does become law, if in your infinite wisdom you do pass this out of the House.
Yes, good to see you, Mr. Chairman.
Good to see you.
Could you refresh my memory, because could you talk about a little bit about the composition of this work group, and would the Senate President and the Speaker appoint a member too? So would the legislature be represented?
Sure. So the work group is on page 2, lines 6 through 17. So it'll have the Attorney General will staff the work group. The Chief Justice of Maryland, of the Supreme Court of Maryland will appoint 2 members from the Supreme Court, from the judiciary, and 2 members will be appointed by the Attorney General, and then 1 member from the Senate appointed by the Senate President, 1 member from the House appointed by the Speaker of the House.
Any further questions? Seeing none, thank you very much.
Thank you very much.
That concludes Senate Bill 827. We'll go to Senate Bill 34. Senator Carter, please.
Good afternoon, members of the House Judiciary Committee. Mr. Chair, would it be okay if my intern, Jack Cochran, joins me at the trial table? He is just here to observe, not to testify.
That's fine.
Thank you. Members of the House Judiciary Committee, Mr. Chair, Madam Vice Chair, committee staff, it's good to see you again, and all members of the committee, of course. I'm State Senator Jill Carter, and I represent Baltimore City 41st District. You've seen this bill many times before. It's been sponsored many times in the House and the Senate. I initially sponsored it with the cross file of your former colleague, Juanica Fisher, followed by Delegate Nicole Williams, and now I'm happy to have had a cross file of this bill this year by none other than Delegate Robertson. This is simply a bill that expands our jury pools potentially and allows them to be the diverse and expansive jury pools that they're designed to be, and actually helps all of our constituents across Maryland by enabling more people to serve on a jury. It creates less of a burden on all of our constituents. This bill has passed the Senate and the House in different forms at different times, but never simultaneously. And so it's been amended. There are some exclusions. What this bill does in its current form, and I hope you will pass it in this form, is that it says that anybody with a criminal conviction can serve on a jury. Not that they will be selected to serve on a jury, but they can get that summons and show up at the courthouse and let the lawyers in the court weed out the people that aren't fit or shouldn't be there and shouldn't be allowed to serve, with the exception of these people. A person that's been convicted of perjury, a person that's been convicted of witness intimidation, a person that's been convicted of jury intimidation, bribing a public employee, or bribing a juror. Under this bill, those persons would still be excluded from even getting a summons to show up at the courthouse. They wouldn't go through voir dire. They're categorically prohibited. This is the last area of which I'm aware where we continue to categorically discriminate against a group of people for no legitimate reason. Because everyone here, based on all of the bills and laws we've passed over the last number of years, is well aware of the fact that we believe that people have a right to be restored to full citizenship and rights once they've paid their debt to society. Many years ago, we restored the right of people to vote that had criminal convictions. Under our current law, we not only discriminate against certain people convicted of certain felonies, but we continue to discriminate even against people that have committed misdemeanors, because the law is that if you've had a sentence and served a year, more than a year, you are categorically prohibited from serving on one of our juries. I'm finished. Except may I conclude really briefly. Another thing that's really important I just want to bring out is that in Baltimore, a news outlet reported that since September, 4 homicide trials, 2 attempted murder trials, and others were postponed and delayed because of a lack of available jurors to serve. And so I want to bring home how this is actually a public safety bill as well. Thank you.
Thank you, Mr. Carter. Thank you, Mr. Chair. Senator Carter, good to see you. I have just one quick question because you brought up voir dire and I had a question. So if this bill passes, would either of the attorneys be able to ask on voir dire if you have a criminal record and what that is, and Would they be able to do that?
Absolutely. There's no limitation to what could be asked in voir dire, and certainly we still have, at least for now, we still have both peremptory strikes and for cause strikes. So, anyone currently that says they can't be fair can be stricken. And so I think the inquiry in voir dire could include that, but also a further inquiry as to whether or not you can be fair. But these people that are excluded under this bill, they won't even get that. They're not going to get to that point.
That's what I wanted to make sure I understood what you were saying. So you were saying that the exceptions wouldn't get to the ones where, you have a crime relating to the bribing of a juror and things of that sort. Are you saying
under this bill, anybody excluded continue to be excluded under this bill? They don't get to voir dire. Just the existence of these prior convictions completely excludes them. They don't even get to go through the process.
Okay, I just wanted to make sure I understood that sentence. Okay, I got it. Thank you.
Thank you, Mr. Chair. Good to see you, Senator Carter. I just wanted to check, does the sponsor of the House bill of the cross file have any issues with your amendments?
Not to my knowledge.
Thank you.
I would encourage the House sponsor to accept these amendments, and hopefully we can finally get this bill passed.
Okay. All right. Any further questions? Delegate Tomlinson.
Thank you, Mr. Chair. Good to see Senator Carter. So I just want to make sure I get this straight. So currently the law is if you've received an imprisonment of more than 1 year, but if you end up serving, I don't know, half the amount of time, so 6 months, you're still disqualified. Is that correct? Or is it only if you
I think that we kind of modified it so that if you've served a year or more, you are excluded.
Okay. Gotcha.
So, but that could be even as low as certain traffic offenses. It could be a DUI. It could be a myriad of things.
Other questions? Seeing none, thank you very much. That concludes the testimony on Senate Bill 34. Senator McCray is here next. Senate Bill 181. We'll hear from
I've
you.
still got another one. Sorry.
Okay, 623. Oh, no, you do. Sorry, go ahead. Sorry. Senate Bill 623. We'll do that one.
Thank you, committee. Briefly, this is the bill that you all passed last year, and it's currently cross-filed again by Delegate Marlon Ampry. I don't need to discuss with you the connectedness, the nexus between education and crime and recidivism. This is simply a bill that would help to improve and increase education in our criminal system, in our prison system, and hopefully cut down on recidivism. According to the information that I have, we have about a 40% recidivism rate in Maryland. We have, we rank within the top 25% of states with the highest recidivism. What this bill does is establishes a prison education delivery reform commission. It is very clearly laid out in the bill what that commission is charged with doing. You heard testimony earlier when you had the full testimony by the House sponsor from those stakeholders and experts who talked to you about the fact that many of our current inmates don't even qualify for the programs that are available educationally or Pell Grants because they don't even have GEDs. We need to find ways to help further the education of the inmates, meet them where they are, get them ready for not only GEDs, high school equivalencies, but college, and help them avail themselves of the programs that are available so that when they come out, not only do they have a better sense of themselves, a better ability to discern between right and wrong, but a better ability to have options in society for employment and other things that require skills and education. And so I would ask for a favorable report for this bill. I think it really is a great step in the direction of making sure that we are providing for a better and safer society by putting people in a position where crime is the least of their options when they come out of prison.
All right, seeing none, that concludes the testimony on Senate Bill 623, and now we're done.
Thank you so
Senator
much.
Carter, thank you very much.
Enjoy your day.
Senator McCray, please. Senate Bill 181. And Senator James. Senator McCray.
How are you doing, Mr. Chair, Madam Vice Chair, members of the committee? I don't make it over here too much to this committee, but I'm here. And for the record, my name is Corey McCray. I'm the senator for the 45th Legislative District. I'm here in reference to Senate Bill 181. It looks like Senate Bill 181 was the cross-file to House Bill 488, Delegate Malcolm Ruff. Senate Bill 181's posture is different than what it was introduced, Mr. Chair. It turned the shall into a may. This is pretty much a program that works for folks that were formerly incarcerated to make sure that they can shift the trajectory of their life from that standpoint by working on vehicles and learning the automotive industry. It looks for funding for this bill, like the governor may be able to fund it for $1 million. It gives specific years, 2026 to 2028. And I can say, Mr. Chair, that we've already put in the budget that you all just passed, contingent upon this bill passing, that it already has the resources to be able to start this fiscal year.
Are there any questions? That was her question. All right. Seeing none, thank you very much. That concludes the testimony on Senate Bill 181. We'll go to where are we going? Senator James, please. Senate Bill 89, please.
Thank
Go
you.
ahead.
Thank you, Mr. Chairman, and it's nice to be here. This is a bill that you've seen a couple years in the past, but it is quite a bit different. I inherited the bill from a delegate, but once I got involved, I began to work collaboratively with the state's attorneys, public defenders, and others. And this bill, I believe, is a collaborative effort, as I'll get to in just a moment. You might recall from last year, and if you don't, I understand there's a lot of bills out there. This bill is premised on a Georgia legislation, which was inspired by, there's a federal statute with the acronym of CAPTA, Child Abuse Prevention and Treatment Act. But in that, the states get federal money, and part of the obligation on the states is to be more transparent and accountable to the public in cases such as child fatalities and near fatalities, which are devastating and awful in and of themselves. But the public, when they're not given any information in a timely fashion, it's almost worse because they begin to believe or think things that may or may not be accurate. So Georgia and many other states, but I worked with Georgia. This statute is real. This bill is really a culmination of that effort. I also worked very closely with the state's attorneys. It's not a big difference what I'm doing in the bill, but it's subtle and important. It does press the department to be more forthcoming after a 30-day period of which they consult with the state's attorney, make sure there isn't any way that any information disclosed would undermine a prosecution or even an investigation. And then and redact information if they can still provide some public information. Then at the conclusion of any investigation by the state's attorneys, then go ahead and give the balance of the information. What I can tell you is that the Maryland statute that I'm amending was enacted quite a lot of years before the CAPTA provisions that I'm trying to fulfill with Maryland. And I think the state's attorneys would probably tell you, and I don't blame them. I can understand the reluctance of state's attorneys. I think the state sort of fell into a default mode of, we're not going to say a thing. We're not going to give a word. We're not going to ever mention it. And hopefully nobody asks this. And I think people stopped asking about these cases. So this is really just saying, let's modernize ourselves. Let's be transparent. Let's hold ourselves to the same kind of transparency we hold ourselves in other parts of state government. And then sort of the last thing I want to say is that there are 2 or 3 state organizations. One of them is the State Council of Child Abuse and Neglect. I brought them in. I brought them into the Joint Committee for Children, Youth, and Families to have them testify. And what they told me, along with the state's attorney, is, look, we're not even getting this information, and we have to provide policy. So there is really, we've fallen into a bad default position of just giving out no information. I just spoke with Secretary Lopez, and I'm very hopeful that he will come aboard and send you a letter of support shortly. So thank you.
Thank you, Mr. Chair. Thank you. Good to see you again, Senator.
Good to see you.
Yeah, I see it's at one point OPD came in unfavorable, but now I see a little farther down, there's some late testimony they submitted that says they've withdrawn. Is that your knowledge that they've withdrawn their opposition?
What was the acronym you used?
OPD, Office of Public Defender?
Yeah, I call them just yes, they a little bit misunderstood the bill. I was so glad they reached out to me by email and then put that in. So I always like to collaborate. So as soon as I heard they had any concern, I called them and we talked it through, and they were nice enough to send that follow-up to say, look, we misunderstood it. We're fine with it. So thank you.
The concerns they raised were just sort of like privacy concerns. And does the bill address that now?
Yes. Well, first of all, I think they misunderstood the bill a little bit, but putting that aside, I went ahead, even though they didn't ask me, and the original bill actually did take some language out. And I didn't, have enough time to get into it, but my last amendment, which you'll see, I put that language right back in, and that language says, this look is at us. It's at the state. What did we do or not do to protect these children? The OPD was worried about whether we were going to disclose information about families or children, and that's not what we were doing.
The information should still stay in-house, or we're not going to release the name of the
Well,
child to the
I didn't change any of that. If you read the whole statute, my little changes have nothing to do with that child. Information is absolutely sacrosanct. And it's never disclosed, right?
Okay, wonderful.
Yeah.
Okay, thank you. Thank you.
Sure.
Any other questions? Seeing none, thank you very much.
Thank you very
Senator.
much. Thank you.
All right, now we'll go to the governor's office. Senate Bill 480. This is an administration bill. I think it comes back to us a little bit different than the way we sent it over to the Senate. Mr. Lutke.
Correct, Mr. Chairman. Thank you. For the record, Eric Lutke, Chief Legislative Officer to Governor Wes Moore. You are correct. This is the Senate version of the Protecting Election Officials Act of 2024. Both chambers made slightly different amendments to the bill. You'll recall the House amendments that this committee added in counsel to the State Board of Elections and counsel to the local boards of elections. The Senate did not add those, but they added student pages who participate in election administration. They added other individuals who take the oath of office to administer elections. And they also made the bill an emergency bill to ensure that it was in place in time for this year's primary election. The administration would encourage the committee to adopt those amendments as well as adding the House's amendments. We believe that all of the groups that were added are reasonable groups to add to the bill.
Thank you, Mr. Chair. So I didn't hate this bill. I didn't vote for it on the House side, but there's one piece that I just was wondering if you might comment on. And the thing that deterred me was the emotional distress piece. It's so squishy and amorphous. Is there any chance that the administration would consider tweaking that language so that it can be a little tighter, so that some of us who are concerned about, feelings getting hurt and people going to jail over that, might be able to address that? And also the penalty is so high, you become a prohibited person permanently if you're charged with this and convicted. So any chance you guys might be flexible in some of that? He's very excited. He loves me so much.
I would say that in the version of the bill that left the House, those two elements remained as they are in this bill, and we fully support that version of it. I would say that emotional distress, that language came from the harassment and stalking statutes, which this committee has passed in the past. It's not a question of somebody's feelings being hurt. There's a higher legal standard than that. And in the case of something like doxing, or some of the other bad behavior we're seeing directing at election officials, we believe it's important to retain that language in the bill.
Two-piece, would you be amicable?
We continue to support the penalties the same way they left the House.
Okay, thank you. I appreciate it.
Anybody else with questions? Seeing none, thank you very much.
Thank you, Mr. Chairman.
Concludes the testimony on Senate Bill 480. Senator Mouts. Things we do. Oh, are you doing it for Senator? Oh, I didn't know that. Okay. All right. I think that, okay, so we are going to do a bill hearing for Senate Bill 809. And I believe it is slightly different than the way that we passed it out of the House, and that it. Oh, this is not working? I'm sorry. Okay, let's try this again. Senate Bill 809 is the same, except that they would not be seeking permission to use a polygraph for correctional officers at the detention center in Dorchester County or with the Dorchester County Department of Corrections. I don't think we have a new delegation letter with that, so that can be the hearing because that's effectively what it is. And I'm looking at Delegate Sample Hughes. We would be waiting for a delegation letter anyway. So we're gonna need something from the delegation as to whether they support the bill with, the new version or not.
Okay. I will
So
make sure that happens.
yes. Yeah, so, but I will just say for the record, usually we do see these bills because they want to use a polygraph on the correctional officers. And so we can't wait to hear why they're not here, but the paramedics in the 911 center are. So, which comes out a little wrong. I mean, no disrespect, just we're kind of wondering why it's that. I am wondering why it's that different. And you may not know. That's fine.
That information from Delegate Hutchinson and Senator Mouse. Okay.
Sounds good.
All righty.
Thank you. We're not going to take questions. So we're going to. What are you doing? Okay, that concludes Senate Bill 809 and concludes the bills for today. We're not going to be voting today. Members of the committee should anticipate bill hearings all Tuesday, going all the way through the next week, likely voting sessions after bill hearings all week next week. And so just be aware that the busy time is upon us. And so we'll leave it at that. That concludes the House Judiciary Committee's hearings today. Thank you very much.